The District of Columbia Court of Appeals has just issued a major decision on whether or not police and government have a legal duty to protect us. Of course, we know the answer. The answer is no. Government and police have no general duty to protect us if we get killed by a criminal or any way hurt in some respect. That's not the government's problem or the police's problem. This is why we have to be able to protect ourselves in various ways, including by being able to keep, possess, and carry firearms for our own personal self-defense. Stay tuned, and I'm going to tell you about this DC case and why it reaffirms what we have always known and what has always been true, which is we are our own first responder. Another terrible instance to prove the point coming up. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, constitutional attorney, member of the United States Supreme Court Bar, proud American gun owner, and best-selling author. If you have not subscribed to the Four Boxes Diner YouTube channel or follow us on @4boxesdiner on Twitter, please do so and show your love for the right to keep and bear arms as we try to expand this channel as far as we can, as fast as we can. The bottom line is this: under American law, there is no duty on the part of government or police to protect your life absent what's known as a special relationship, which rarely occurs unless you're in prison or maybe you're a confidential informant for the police. Again, unusual circumstances. And this proposition was reaffirmed in a tragic case just a day or so ago in a case called Hudboyoy. I think that's how it's pronounced. It's Nafisa Hudboyoy versus the District of Columbia. That's the name of the case. I'll put a link to it down below. In this case, what happened, it was a terrible story. You had a man who had committed apparently murder about 20 years ago. He was exonerated from the murder charge on the grounds that he was mentally insane. He was then committed. Many years later, in the year 2003, this gentleman by the name of Hillman Jordan was let out of the mental health institution, back out onto the streets. While he was out on the streets, he illegally acquired a firearm and then threatened to kill one or more people. He was then recommitted into the mental health institution and was kept there. Then, a few years ago, Mr. Jordan was released and moved into an apartment above a man named Mr. Buteau, Joade Buteau. Now, it turns out that Mr. Jordan had a tendency to smoke a lot of pot, and everyone in the apartment complex knew it. But nobody in the apartment complex apparently knew that this guy was a murderer who had got off only by virtue of claiming insanity and was found to be insane, and then had been recommitted to a mental health institution after threatening to kill multiple people, one or more people. Nobody in the apartment building knew this, including Mr. Buteau and his wife. So then what happens is, unfortunately, Mr. Buteau complains via email about the fact that Mr. Jordan is making a lot of noise, staying up all hours of the night, and apparently smoking marijuana. Then what happens is that Mr. Jordan somehow gets access to this email and realizes that his neighbor has complained about him to the superintendent or the building owner, whoever it was. So what does Mr. Jordan do? Of course, we know what he does. He kills Mr. Buteau. He kills him. Now, a lawsuit ensues by Mr. Buteau's wife, claiming that the government of the District of Columbia failed to act reasonably and thus acted negligently, and that was the cause of Mr. Buteau, the husband, being murdered by Mr. Jordan, and that the government of the District of Columbia should pay Mr. Buteau's wife compensation for the death of her husband. So what did the court say? Well, the trial court said, sorry, we understand that the government knew that Mr. Jordan was a murderer, had been found insane on multiple occasions, had killed people before, he had threatened to kill other people before, and that he moved into the apartment. And moreover, one of the 17 conditions that Mr. Jordan, the killer, had to satisfy was to not use illegal drugs. And it turned out that the government was testing Mr. Jordan for drugs the whole time, and lo and behold, Mr. Jordan was caught on multiple occasions having ingested and used illegal drugs, marijuana. The government knew this. So not only did the government not tell anyone in the apartment building that they had a murderer living amongst them, they also, when they realized that Mr. Jordan was committing all sorts of violations of his conditions of release and should have been returned back to the mental health institution, the government says, nah, don't worry about it. It's good. I know he's violating the conditions of release. We don't care. Whatever. Let him out. We're not going to do anything about it. Well, of course, by virtue of letting him stay out on the streets, Mr. Butoh was killed by Mr. Jordan. And what happened? The trial court says, sorry, nothing we can do. No obligation to protect you. The government doesn't owe you a duty to protect. The police don't owe you a duty to protect you. Sorry, you have no claim. So this goes up to the Court of Appeals in the District of Columbia, and the District of Columbia, citing to and relying upon, among other things, the Supreme Court cases of DeShawnee versus Winnebago, as well as the town of Castle Rock versus Gonzalez, says, sorry, government and police have no duty to protect you. We appreciate you trying to get around this with exceptions. It's not going to work here. Sorry, Mrs. Butoh, you've lost the case. I'm sorry you lost your husband to this crazy guy who murdered him, but it's not at the end of the day, we're not going to pay the bills. We're not going to pay you any damages for wrongful death or negligence or anything. And the Court of Appeals says, yep, that's right. Sorry. No legal obligation. So again, my point here is this is another example that you must always remember that the government and the police have no duty to protect you. You must tell all your friends. You must let people know, because when they say, let the police come and save your life, the police should have guns, but you shouldn't have guns, they'll take care of business. You know and I know you call BS on that immediately. And if the government really intended to protect our lives, they would at least be legally responsible for doing it. And if they fail to do so, they should be paying major damages to crime victims and to their families. But the government's like, no, we're not going to do that. So we're going to pretend that we owe you an obligation. We're going to pretend that we have a duty to protect the public, but it's all BS. Because legally, if there is no remedy, if you cannot sue them in court or put them in jail for failing to do their job, guess what? They don't really have to do that job. There's no remedy. There's no right. If you have no remedy against the police or against the government for failing to protect you, you have no right to that. Bottom line is, you are your own first responder. The police are not first responders. They are second or third responders at best. You're the first responder that deals with the criminal, the sick person, the fire first. So never forget this for 1 second. Okay, I hope you learned a little bit something about this tragic story and this terrible precedent, but it is the law of the land. Never forget this. To serve and protect is not accurate. It is a marketing slogan. It is not the law. And again, if you enjoyed what you heard, please subscribe to the Four Boxes Diner. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.